My name is Sidney Ross. I'm a member of the Succession and Trusts group at 11 Stone Buildings, Lincoln's Inn, which is a chancery and commercial set. My practice involves will and trust drafting, trust administration and wills disputes. But the principal area of my practice, which accounts for over 50% of the work I do, is claims under the Inheritance Act, and I am in fact the author of Inheritance Act Claims, published by Sweet and Maxwell, 3rd edition 2011. The aim of this talk is to provide an insight into the way that courts approach the questions of determination of the substantive claim that's being made, and also questions of costs. For these purposes, I've taken as illustrations two recent important cases. I emphasise that they're illustrations because 1975 Act claims are highly fact-specific, and when one's studying the case law, it's necessary to concentrate more on the principles underlying the outcome than the actual outcome itself. In that way, practitioners handling these claims will be better able to concentrate on three important aspects of case handling. The first of these is managing the client's expectations. If one doesn't understand the principles according to which these decisions are made, one is not going to be able to put to the client what their reasonable expectations might be, and also failing to manage the client's expectations is going to lead to increased costs. The second point is that because Inheritance Act claims are conducted under the Part 8 regime, which involves witness statement accompanying the claim form and witness statements in reply, it's very important to ensure that the client's written evidence deals with all relevant matters and doesn't have anything irrelevant in it. That again is very important in controlling costs. The court will always favour concentrating on the main issues and avoiding spending time on matters which, although they may be important to the client emotionally, are not going to assist the court in determining the outcome of the claim to any great extent. And that leads on to the third point, which is that one should always have in mind the possibility of dealing with these claims without recourse to more litigation than is necessary. So if the client's expectations have been properly managed, that should lead to reasonable offers of settlement, whether by negotiation in correspondence or by alternative dispute resolution. Mediation is the commonest method of ADR, but there is now in existence a scheme run by the Institute of Family Law Arbitrators, under which Inheritance Act claims can be submitted to arbitration.